Now let's study position of privity of consideration in India. The principle of the doctrine of privity of consideration is not applicable in India. It is applicable in Britain but not in India. According to the Indian Contract Act 1872, the definition of consideration in section 2D states, consideration may be furnished by the promisee or any other person, as long as it is at the desire of the promisor. Thus, the consideration may move from promisee or some other person if the promisor has no objection from any other person. So this means the consideration may move from any person. It's not necessary that the promisee has to furnish the consideration. So the best example in this case was the case of Venkata Chennaiya versus Venkata Ramaiya Garu, 1881, and that was in Madras High Court, which is now in Chennai. So in this case, as we have already studied, that the consideration moved from a party to contract who was mother towards her daughter, but in favor of her sister. That is, her sister was promisee, her daughter entered into that contract, promising that she will pay consideration or annuity to her mother's sister or her aunt. So, but to her aunt, on part of her aunt, she was not paying any consideration to her niece. So, in this case, because she was not paying, but the consideration was moving through her sister, who was mother of her niece. So consideration can move from any party to contract or any other person, or promisee or any other person. So she was a party to contract, and consideration was moving from the party to contract, who was her mother, but promisee was not moving it. A party to contract was moving it, but she was not the beneficiary because she was paying consideration. She was giving her property to her daughter, but she was not getting consideration. So who was getting consideration in her place? So her sister was getting consideration. So consideration was moving from a person who was not receiving consideration, but consideration was in favor of another party who was promisee. She was promisee because she was supposed to get annuity or that consideration. So consideration can move from any person. It is not necessary that the promisee must move consideration. So this is one of the examples, because at the desire of the promisor, because promisor was mother here and she desired that she is moving consideration on her part and in favor of some promisee who was not herself but some other person, in this case her sister. So as the promisor has no objection, she has moved consideration for her sister, so it was not private to contract. So doctrine of privity is not perfectly applicable in India, it is applicable in Britain. If had it been the case of Britain, then consideration must move from party to contract. So if it was a case of Britain, then consideration would not be payable by the daughter to her aunt. But in India, it was payable. Then this was confirmed in the case of Kedarnath Bhattacharjee versus Gauri Muhammad as well. So these are references. Now, privity of contract or stranger to contract. The doctrine of privity of a contract is a common law principle which implies that only parties to a contract are allowed to sue each other to enforce their rights and liabilities, and no stranger is allowed to confer obligations upon any person who is not a party to contract, even though contract has been entered into their benefit. So this is a generic idea thereof. But and this is fully applicable in Britain. But in India, we see that when a contract has been entered into in the interest of any third party or some other party as well, or some third party is being made promisee, then it will be applicable, and there will be no privity of contract, and a stranger to contract can also become a promisee or a beneficiary. So as we observed in the cases of this Chennai, where the mother moved the consideration in favor of a sister. So the privity of contract is perfectly applicable under English law, but position of privity of contract in Indian law is slightly different, because consideration can move for the beneficiary or for the promisee by any other person as well. In India, like the Supreme Court biased decision in MC Chacko versus State of Travancore in 1970, in a far-reaching attempt of clearing ambiguities in application of the Doctrine of Privity, held that a person not a party to contract cannot, subject to certain well-recognized exceptions, enforce the term of the contract. So here in the case of Chennai, we observe that exception. The recognized exceptions mentioned in the quoted judgment are worded widely so as to cover the beneficiaries, or what types of beneficiaries are there. It is stating under the terms of the contract. Views on the rights of third party beneficiaries have been laid down by other courts of India as well. So there are different sorts of rulings that come up, or they keep coming up from time to time. Like one of the examples can be Bhujendra Nath versus Sushmoi Basu. That was in Calcutta High Court in 1936. The division bench of the Calcutta High Court held that a stranger to a contract which to his benefit is entitled to enforce the agreement to his benefit can do that. Like who is a stranger to contract means who is not a party to contract, but if the contract is in their interest or in their benefit, they are entitled to enforce the agreement or the contract in their benefit. Also in case of Pandurang versus Vishwanath, it has been held that a person beneficially entitled under the contract can sue even though not a party to the contract itself. So these were the examples that we can study. We can study detailed judgment so that we can have a more proper idea or a better idea. But we have somewhat idea or a generic idea that is quite sufficient to understand that doctrine of privity to contract and doctrine of privity to contract and regarding consideration. Like what is applicable in India and what is the generic idea. The generic idea is fully applicable under English law, and in Indian law it is not fully applicable, as there are exceptions where consideration can move from any other party than the parties to contract. And under English law it is they do not allow any other party or any outsider or any third party to sue any of the parties to contract, because they are not allowing consideration to move by any other person than promisee. Because if consideration is not moving by the promisee themselves, so because the people who enter into the contract, they have entered into a contract. But if they give benefit to any other person, but they are not moving consideration, so they will not allow the parties to contract to sue. So this is the basic thing, that why they are not allowing any outsider or any party who is stranger to contract not to sue any of the parties who are parties to contract, because they are not allowing consideration to move any person other than the promisee. This is the basic reason or the main reason.